It is a significant downgrade in accommodations, from the Bahay Pangulo in the Malacanang Palace complex in Manila to a cell in Scheveningen prison on the outskirts of The Hague. Such is the trajectory charted by Rodrigo Duterte, president of the Philippines between 2016 and 2022, father of the current vice president of the Philippines, now awaiting trial at the International Criminal Court on charges of crimes against humanity. The indictment accuses him of ultimate responsibility for dozens of murders committed during his crusade against the Philippines' drug dealers, in which thousands of people were killed. Duterte is the highest-profile suspect landed by the ICC in some while, and proceedings will be watched with interest by some other recent indictees: Russian President Vladimir Putin, Israeli Prime Minister Benjamin Netanyahu, Afghan Supreme Leader Hibatullah Akhundzada. When Duterte's pre-trial proceedings begin on February 23rd, the concept of international justice will, once again, also be on trial. Our modern idea of this kind of justice derives from the trials of German and Japanese commanders after World War II. Speaking at Nuremberg, the United States lead prosecutor, Supreme Court Justice Robert H. Jackson, said of the crimes on the docket that they were so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. Subsequent similar tribunals have tried crimes committed in Rwanda, Sudan, the Democratic Republic of Congo, and the former Yugoslavia, among other jurisdictions. There have been convictions. There have also been complaints to the effect that the process is opaque, complex, and tends inevitably to focus on the leaders of poor countries which lost. Is the prosecution of individual leaders any deterrent to crimes committed by governments or militaries? Are we getting any better at bringing heads of government to book? And what's it like trying to defend one? This is the Foreign Desk.
Both the plaintiff, the complainants, the victims, as well as the defendant himself would appreciate the professionalism and the outright impartiality attached to a tribunal such as the International Criminal Court.
The examples of the past are really interesting, of where somebody feels that they are powerful and can do everything, and then everything crumbles away.
I think if prosecutors were a little bit more willing to hone in on the key criminality and not charge the kitchen sink, that international trials wouldn't be so bloated.
You're listening to The Foreign Desk with me, Andrew Muller. Our first guest is Diane Desierto, a professor of law and global affairs at Notre Dame University and director of the LLM program in international human rights law. Diane, if we look at the predicament of former President Duterte, is it better, do you think, that he is tried in The Hague by the International Criminal Court than by a court at home in the Philippines?
I think it's important that he receive accountability, and that accountability, the choice of the accountability mechanism is dependent on the victims themselves. And this choice, in this instance, victims chose the International Criminal Court.
I mean, beyond those victims, though, of which there are clearly many, and their families, of which there are many more, is the trial likely to be keenly followed in the Philippines?
Well, I'm a practicing lawyer in the Philippines, Andrew, so part of my professional responsibility obligations is to say I hope so. But given that the average time with which prosecutions are conducted in the Philippines, especially when we're dealing with a former president that has infinite resources to litigate at his disposal, one could say that the average disposition of cases, criminal cases in the Philippines, from trial proceedings all the way to exhausting appeals and any dilatory tactics and motions, that could well on be 25 years.
I mean, is that, though, right there, not an argument against the ICC as opposed to a domestic court? Because if Duterte does succeed in tying proceedings up for basically ever, he won't be the first.
Oh, no, I was referring to the Philippines. It's 25 years. courts in the Philippines. It's infinitely faster at the International Criminal Court. So I'm not surprised that victims chose to submit, and the many, many victims who have chosen to make submissions to the prosecutor did so because in this instance, they would have an impartial, more expeditious and accountable tribunal, especially given the scope of what's involved here. We're looking at the crime against humanity of murder.
Mm.
And so these are crimes not just, and while there's, of course, against the Filipino people, the characterization of the crime as a crime against humanity is important.
Do you think then that a proceeding at the ICC might be seen by Filipinos as perhaps more impartial? Because there has been some suggestion that there is a domestic political dimension to his arrest, that he was elbowed into the arms of the police by President Marcos as part of the Marcos-Duterte family feud.
I should think that all parties would welcome the impartiality of a court that was not selected by the Philippines, by any party in the Philippines. No judge was ever appointed by any party in the Philippines, and thus the kind of levers of influence that could ordinarily be exercised when you're litigating in a home court would not be present here. So I would actually think that both the plaintiff, the complainants, the victims, as well as the defendant himself would appreciate the professionalism and the outright impartiality that would be attached to a tribunal such as the International Criminal Court.
Do you think there is any risk, though, and I realize that there would be a risk attendant on a trial like this anywhere, of giving Duterte a platform, making him some kind of martyr, to the possible advantage of his still very powerful family? To remind listeners, one of his children is the vice president, another is the mayor of Davao City, and another is a congressman.
So, Andrew, no one is depriving any person accused of a crime of any rights of expression, in this instance. So he's still presumed innocent. That's why we're undertaking international criminal proceedings. Whether or not he's in The Hague or in the Philippines, he will relentlessly have a platform given the resources that he and his family have at their disposal. The question is whether victims will have that kind of platform themselves. In the first instance, we have to recall that when the drug war began, many victims did not have this kind of platform because the threat of retaliation emanated directly from the president himself. Those who complained, those who criticized, those who said that the prosecution of this drug war should not be targeting any civilians and law enforcement procedures should be followed, none of them could get any recourse. So if we're talking about platforms, I think the accused has an infinite array of platforms at his disposal. The victims do not.
There is, though, still the fact that Duterte's war on drugs, lawless and reckless and willful though it was popular with a not inconsiderable section of the Philippines population. Do you have any hope, or is there any hope, that putting him on trial for it, whether he's convicted or not, may interest successive or succeeding Filipino politicians in the rule of law again?
Yes, I should think so. What was unfortunate in a climate of extensive fear that was propagated during that time. One was it persuaded people to bury their heads in the sand and think that so long as their enclaves were not affected, that was okay. And somehow this is just law enforcement operations. But what we're seeing around the world that didn't just begin with the Philippines is the increasing militarization of civilian societies. The kind of force that is deployed now by presumably law enforcement that is professionally trained no longer, as in the case of the drug war, limits itself in the amount of force, the intensity of force, the weapons at their disposal, the usual constraints of due process and appropriate arrest and enforcement procedures. I mean, I should know because in my own circumstance with my own lawyers and my law firm in the Philippines having been arrested and detained for allegedly allegedly interfering with the search. We were there passively monitoring a search, as lawyers are supposed to do on behalf of our client, to make sure that there would be no tainting of the chain of custody of any evidence that they would seize or obtain from our client. But that couldn't even be done. And so, to the extent that I hope this not only inspires more people, more of my fellow Filipinos, to understand that the Constitution protects everyone, whether they are presidents or whether they are victims, whether they are persons of means or persons without means. I should hope that seeing justice here will remind everyone, from the voter to the politician, that no one is above the law.
Do you think, though, just finally, that lesson stands if we get to a point where, for obvious actuarial reasons, there isn't a verdict? Because President Duterte, of course, is not a young man, and for all that the International Criminal Court may be more efficient than Filipino courts, as you suggested earlier, it has not been known for the briskness of its proceedings. They may well outlast the defendant.
I think under the conditions of his detention at The Hague, which scrupulously observe the Mandela principles and all guarantees of human rights, that there will be every effort to ensure that he obtains and remains and has the ability to enjoy the right to the highest attainable standard of physical and mental health. I do think it's important for the prosecution to be very mindful and conscientious that this would not be Pyrrhic justice, that the victims would be allowed to present their case. And in fact, given that there is so much already well established, I think what's going to be critical is establishing the president's direct hand in it, not only his admission of how he instructed his subordinates to conduct the kind of lawless and relentless persecution of the drug war, but also how he gave his approval for every aspect of that drug war to be conducted in the way that it has been. And I think if the prosecution, which I know very well, this prosecution is very scrupulous, very diligent, and they are very mindful and professional, they will do what is necessary to ensure that the prosecution's case is brought to justice, notwithstanding any of the usual courtroom tactics to delay proceedings.
That was Diane Desierto, Professor of Law and Global Affairs at Notre Dame University. This is the Foreign Desk. You're listening to The Foreign Desk on Monocle Radio. Joining us now in an attempt to diagnose where and when the concept of prosecuting the powerful lost its way is Steve Crawshaw, journalist, former UK Director of Human Rights Watch, and author of Prosecuting the Powerful, War Crimes and the Battle for Justice. Steve, let's start at the start of your book, which is set in Bucha near Kyiv, the site of a massacre by Russian invaders early in 2022. If we think of that as kind of a test case for what the rest of your book gets into, how likely is it that anybody will ever end up in the dock over that crime in particular?
That some people will, I think, highly likely. In other words, people a bit further down the pecking order. There are different places that they might get picked up in future. If we talk about the people right at the top, so Vladimir Putin, for example, is one of those who's been indicted by the International Criminal Court for the overarching responsibility. The short answer is we just never know. At the moment, he's sitting pretty, as it were, and the ICC doesn't, of course, have a police force that can go into Russia. But I think the examples of the past are really interesting, of where somebody feels that they are powerful and can do everything, and then everything crumbles away. So like you, I saw that with Slobodan Milosevic, the Serb leader, who, was very confident when I met him in the 90s that he would never face justice. And then 9 years after that, in 2001, his own new government delivered him to The Hague. Last year, we saw something similar with Rodrigo Duterte with the Philippines, who, again, was trotting around Hong Kong, boasting of the fact that, of course, he was untouchable, flies back home and is delivered to The Hague. Now, can we see circumstances in which that would happen for Putin or other senior leaders? Not at this moment, but when that war finally and somehow, however messily, comes to a standstill, if not a proper end, It will be difficult for Zelensky, but it's going to look very difficult for Putin as well. So those are the kind of big abstract questions which depend partly on international will, but partly on where the society itself goes and how much he becomes disposable. Assad, for example, is another case. He's now sitting in luxury in Moscow, but he has no political value at all. So he could easily be a trading point for Moscow in the future.
I did want to ask about that point about Milosevic, because you do mention it in the book. And to be clear, you put this to him personally reasonably early on in the Yugoslav wars, that there was perhaps a possibility that he might end up answering for this at some sort of Yugoslav-themed Nuremberg. Did it strike you that that thought had just genuinely not occurred to him until that moment?
So the meeting you're describing was at the end of a big international conference that happened in London in summer of 1992. So a few months after the Bosnian War had begun, and I was just fresh back from a trip to Sarajevo, the besieged Sarajevo myself. And it was all over the front pages at that time. And in that conference, for the very first time, there had been talk about a potential war crimes tribunal, which would, of course, have been and became the first since Nuremberg like that. So he was certainly aware of the concept. But I think that he, to be honest, like most people, didn't really take it very seriously. And as I say in the book, not only do I think that he didn't think he would ever face there, he was quite contemptuous in a sense, like baffled and contemptuous when I asked if he might end up there. But as importantly, in a sense, was that I also, and most other people, completely wouldn't have expected it, because you expected, even if this tribunal was created, it would deal with the little people. And to be fair, for many years that was the case, and people from the tribunal themselves told me, but told others as well, stories afterwards about how they were held back and not allowed to go for the big people, because then, to some extent now again, sadly, but then there was this classic narrative was like, oh, we need the big people because they are the ones who pragmatically we will do the deals with, failing to understand what came later as an understanding that actually it may seem to give you, be helpful to deal with the bad guys because they have the power and they can help unlock things and this, that, and the other. But actually, it blocks the possibility, not just of justice, but of stability as well in the future. So gradually, but it did take a good few years to percolate up for the indictments to come for him and some of the other senior Bosnian leaders.
Was there also a sense, though, by the 1990s that this was just not something we were really taking seriously anymore? Because the chronology of your book does kind of advertently or otherwise frame the decades of the Cold War as something of a missed opportunity, because, of course, you have these two great watershed moments, Nuremberg and the Tokyo trials, where it does actually look as if the world is making a declaration that if you commit crimes, even in the highest of office, you will be run down, you will be tried, you will be punished, and in those cases, you may well even be executed. And then we seem to stop doing it.
That's exactly right. So the Cold War, the 40 years after the Second World War, were a period where everything was kind of put to one side, if you like. Not only was it put to one side, but actually all of the prosecuting powers in their own way were committing serious war crimes. And immediately in the wake of the Second World War, as you say, there was a determination to do things. There was Nuremberg, but interestingly also the Genocide Convention of 1948, which the crazy Polish Jewish lawyer Raphael Lemkin came up with the word and then fought for the convention. That convention, when it finally came, very, very difficult to get, it builds in the fact that genocide should be both prevented and punished. But actually, that was quite abstract because there was nowhere, literally nowhere, where it could be punished at that time. And so I think, as you say, in the 1990s, this was the beginning of change, I think, is the short answer to your question, is that 1989, that kind of turning point that I was incredibly privileged to witness as a journalist working for The Independent. I was East Europe editor, so covering all of those different revolutions across the region, Berlin Wall coming down and so much more. All of that was, in a sense, a prologue to the International Criminal Court, which was agreed in 1998. So that conversation I had with Milosevic in 1992 it was the beginning of an era of hope, which was kind of, I guess, why that idea of the War Crimes Tribunal was put on the agenda, because at that time it felt that the West and Russia, that everybody was kind of pulling together, if you like. And indeed, Russia at the Security Council voted for the creation of that and other tribunals, saying accountability is important. So things have changed so much. That was, if you like, a high point in some ways. Actually, it wasn't a high point. It grew and grew after the 90s, the power of the International Criminal Court and what it was trying to do. But obviously, the past couple of years, especially with the arrival of Donald Trump, but not only, we've seen massive pushback on all of that.
Well, I was wondering if the pushback against it dates from more or less as the 1990s closed, because, of course, we have those high-profile prosecutions, not only over Yugoslavia, but Rwanda, one or two other places. And then comes the war on terror in September 2001, during which the United States decides that certain laws and rules that might have followed in the past, it was no longer going to bother with.
Yes, I mean, that's certainly true, but it was also true that there was wow, we've created this International Criminal Court. There was a speech that the UN Secretary General gave in Ban Ki-moon in 2010, when the crime of aggression was agreed. There was an International Criminal Court conference, and he talked there very confidently about this is, the end of the era of impunity. I think you could certainly say that what we saw with the horrors of the Syria war, which started a year later, 2011, 2012, there we saw complete impunity. And there, crucially, it was to do with protection in the UN Security Council, where Russia, of course, was not going to allow anything to happen on Syria. And what I thought you were going to say, but which is also a really important set of moments, is what we saw first with the indictment for Vladimir Putin and others in 2023. And then crucially, which was generally welcomed by Western governments, and then crucially a year later for Benjamin Netanyahu, Yoav Gallant, and of course for the Hamas leaders for the atrocities of 7th of October. That was the point at many Western governments, not just the US, which never liked the International Criminal Court, but European governments, which were co-founders of the court, but were suddenly, we like it when it goes for people that we don't like, but like now you've gone for our friend, we're not so keen on the court. The top brains, as it were, in the international legal establishment I was talking to would say, obviously we're not going to see an indictment for Putin. He's the president of a permanent member of the Security Council. That just doesn't happen. And then shortly after that, in spring 2023, the indictment came for that president. So that was really unexpected in ways it's difficult to remember back. And it certainly was not the pattern of what we'd seen elsewhere, where it took a long time to get to the top and sometimes didn't even get there. And then a year later, even more dramatic. Again, I was in Israel just a few weeks before the indictment for Netanyahu and Gallant, his defense minister. And again there, but also in other countries, people say, that's not going to happen. Of course, it should happen, because the idea is that justice is blind. It doesn't care whether you're important or not. It merely cares what crimes you have or have not committed.
That was Steve Crawshaw. His book, Prosecuting the Powerful, War Crimes and the Battle for Justice, is out in paperback now. This is The Foreign Desk. This is The Foreign Desk with me, Andrew Muller. Assembling a trustworthy apparatus for prosecuting the powerful is very clearly easier said than done. We're joined now by someone who has helped do it. Kevin John Heller, Professor of International Law and Security at the University of Copenhagen Centre for Military Studies and Special Advisor to the Prosecutor of the International Criminal Court on War Crimes, and who also worked for the defence during the trial of Radovan Karadzic, former President of Republika Srpska, who was indicted by the International Criminal Tribunal for the former Yugoslavia during the Bosnian War in 1995 and arrested in 2008 after some years masquerading as a New Age healer in Belgrade, specialising in something called human quantum energy. Kevin, let's start with your former client. How did you come to work for the defence of Radovan Karadzic in the first place?
I was an academic living in the Southern Hemisphere. I had been consulting with a lawyer, defense attorney named Peter Robinson. We were working on smaller cases, both at the Yugoslav Tribunal and the Rwanda Tribunal. And he asked me one day, he said, hey, if the right case ever came up, would you like to be more involved? In the perfect example of be careful what you wish for. I said yes. And a couple of months later, literally, Karadzic was arrested and hired Peter as his defense attorney. And Peter said, hey, remember when you said you wanted to get more involved in a case? And that's really how it started.
I know you wrote about this at the time because I know that there were people around you who had a certain amount of difficulty with you deciding to do this, but it's important that to the legitimacy of courts like the ICC or the ICTY in this case, that defendants actually do get a fair trial, however appalling the acts are that they're accused of.
Absolutely. How can you have any faith in a conviction if that is in fact what results, and what did in fact result in the Karadzic case, if they don't have a good defense, if they don't have resources, if they don't have high quality defense attorneys? The legitimacy of the system depends on both sides being equal and both sides being skilled.
So where do you even start assembling a case?
Well, if you're working for the defense like we were, the key, of course, is not to build the case necessarily for yourself, but to carefully dismantle the case of the prosecution. So you really start by closely examining and analyzing what the prosecution's theory of the case is. What charges are they bringing? What particular historical events are they focusing on? Who are the witnesses, and what is the evidence they're most likely to use? And then you slowly, to the best of your ability, dismantle all of the basic planks of the prosecution case.
I mean, in the case of Karadzic, he was, at the risk of giving away the ending, convicted of 10 of 11 counts. The one count he was acquitted of was one of the two charges of genocide brought against him. As far as you understood it, what was the reasoning there? Why let him off on that one specific thing?
I don't necessarily think it's anything particularly specific to the Karadzic case. If you look back at the ICTY and the genocide prosecutions in general, they really never succeeded outside of Srebrenica. The judges were just never really convinced that the acts there really did amount to genocide outside of Srebrenica. And so if you couldn't kind of find genocide on the ground, so to speak, it was very hard to hold the senior commanders, both political and military, to account for it. So I think in general, those charges kind of across the board and across defendants tended not to be successful.
I mean, is that one of the areas in which you would reform the process, maybe stress that if you can get a conviction on something relatively small, it's more expedient and perhaps more transparent to do that rather than attempting to throw the entire book at them?
I think so. I mean, I wouldn't advocate necessarily for the Al Capone approach where you prosecute them for something completely, minor and unrelated to the core of their criminality. I do think that the expressive value of what you charge a suspect with is important. But at the same time, you do have to balance the expressive value, doing justice for all of the various victims. You do have to balance that against scarce judicial resources, lack of judicial time, because I don't think anybody benefits from a trial that lasts, 3, 4, 5 years, and then an appellate process, which of course has to be there, that lasts another couple of years. I think if prosecutors were a little bit more willing to hone in on the key criminality and not charge the kitchen sink, that international trials wouldn't be so bloated. And at the outcome, there's also a negative effect. If you look at someone like Charles Taylor at the Special Court for Sierra Leone, the judges issued a 2,499-page judgment in that case. That's not a useful document. I guarantee you there's probably a small handful of human beings on this earth who have read it from start to finish, including the judges at the Special Court for Sierra Leone. So I think you have a lot of advantages by being slightly more precise and selective in what you charge as a prosecutor.
And having seen the process from the inside, how else would you reform it? Because you wrote at the time quite extensively of the importance of it. And if I can read your own blog back to you, you talk about future generations need to be confident that the verdict resulted from a process that was open, transparent, and above all fair. And I think the transparency thing is probably the most important here, because a trial that goes on for the thick end of a decade is almost by definition not transparent, because everybody has kind of zoned out of that.
Absolutely. And of course, there's the age-old discussion in international criminal law about where do you actually hold the trial. Holding it in The Hague for events that happened in the Balkans is not necessarily, an insuperable obstacle to the victims' groups, being able to follow the trial. But when you have, say, the trials, in of atrocities that take place somewhere in Africa or Latin America, and you hold them in Europe, it makes it very difficult to follow. Beyond that, you need to have a fair trial. You need to have a quality defense. You need to have full disclosure of the evidence by the prosecution. You need to have as many public hearings as possible, acknowledging that sometimes there are sources of evidence, witnesses that do need to be heard behind closed doors. But the more that you can do this in a way that the people who have been affected by the atrocities can follow, I think that's the best recipe for a successful trial, at least with a view to future generations.
And do you get any sense that any of those lessons have been absorbed by similar courts? Because it is obviously now 30 years since attempts started being made to prosecute the people responsible for war crimes in Yugoslavia. Does that sort of, I guess, transparency and expediency and basic speed of process seem to you to be something that is being adopted?
No. I mean, to be fair, the ICC being a court that has, general jurisdiction that can then, potentially investigate crimes all over the world, there is no way to do local justice in that kind of context. The judges could actually go and hear part of cases in the locations. Kenya asked for some of the proceedings in those cases to be held in Nairobi, but the judges refused to do so. So there are things that even the ICC could do. But I think being even perhaps slightly more critical, think about the new special tribunal for the crime of aggression against Ukraine. This is the newest kind of international effort to do justice, obviously, for Russia's invasion of Ukraine. Where did they put the special tribunal? In The Hague. There were certainly many discussions, and I wrote quite a bit about this, that why not put it in Poland or in Lithuania or one of the Baltic states? Obviously, for security reasons, Ukraine probably would have been a non-starter, but you didn't have to just go the same route that we've been going for decades and build a new institution just down the street from the ICTY and the ICC. But nevertheless, there just simply was not the political will to do that.
I mean, and just finally, on that question of proximity, I mean, how important to the process is it that people who are victims of it or were related to victims of it feel like that some actual physical effort is being made to come to where they are and hear them?
Well, it depends on your view of what international trials are supposed to be. If you take a Hannah Arendtian approach and you say that the only thing that an international trial is supposed to do is separate the guilty from the innocent, it doesn't really matter. And of course, I think obviously getting the verdict right is the most important. But beyond that, we do want those who are affected by atrocities to feel a stake in the process. We do want them to feel vindicated by the process as much as we possibly can. And if you put a trial in a place where they can't realistically follow it, whether they can't go to court or maybe even have a hard time, not so much these days, of course, following it on the media, you don't get the buy-in of the affected communities. And I think that is a huge limitation to a trial that is held somewhere very distant from where the acts themselves were committed.
Kevin Heller, Special Advisor to the Prosecutor of the International Criminal Court on War Crimes. Thank you for joining us. That's it for this episode of The Foreign Desk. We'll be back next week with a special episode recorded at the Munich Security Conference, and look out for The Foreign Desk Explainer, available every Wednesday. The Foreign Desk was produced by Anita Riota and Lily Austin. Lily also produces The Foreign Desk Explainer. Thanks also this episode to Christy O'Grady. To contact the Foreign Desk team, you can email Anita at aer@monocle.com, and don't forget to subscribe to Monocle Magazine and our free daily email bulletins by heading to our website at monocle.com. From me, Andrew Muller, thank you very much for listening. Until next time, goodbye.